we are opening the bulletin with some breaking news coming in. The Supreme Court of India has recognized the right to die with dignity. India's top court has upheld passive euthanasia and living will. Let's listen in quickly to some reactions coming in now.
Any condition of the bail is violated by the person. The state has right to move the court for cancellation of the bail.
Thank you, sir.
An NGO named Common Cause had petitioned the Indian Supreme Court to recognize living will of a person. In a living will, an individual can make a statement in advance whether their life should be prolonged using an artificial support system or not. And to give us more information on this, I'm joined in by Jessica Taneja, our correspondent on phone line. Jessica, go ahead and elaborate on this latest verdict.
Well, Akansha, as you already mentioned, the Supreme Court has allowed its citizens of the country the right to die. One has to understand what this living will that we're talking about is under, which has been allowed in particular. So the living will, it's in fact, is a written document that allows a patient to give explicit instructions in advance about the medical treatment which they want, especially when they are, terminally ill or no longer able to express their informed consent. So remember, passive euthanasia was already in 2011, but it was upheld. The Supreme Court has upheld its own judgment, saying that yes, the citizens of the country have the right to die, with dignity, and as whatever happens, and if there is extra care that is required, it's up to the person or the terminally ill patient to decide what treatment would they want, if they would want treatment or would not want treatment in the future.
Right. Jessica, I'm also joined in by Kartikeya Sharma live from the newsroom. Let me quickly cut across to Kartikeya, who will elaborate and add more perspective to this recent verdict that is just out. Kartikeya, how would we differentiate between active and passive euthanasia for all our viewers out there? Dichotomize between these two.
Passive euthanasia, you have voluntary and involuntary euthanasia, you have indirect euthanasia, and there is something called assisted suicide. These are medical terminologies. Now, when we talk about active euthanasia, in it a person directly and deliberately causes the patient's death. In passive euthanasia, they don't directly take the patient's life, they are allowed to die. Now, in passive euthanasia, it's like death by omission. When someone lets the person die, in the sense that you know that you're withholding the treatment, and you know that the act of withholding that treatment, in this case, as Jessica said, life support system, the person will not survive. So that is called passive euthanasia. Now there is something called voluntary euthanasia and involuntary euthanasia. Voluntary euthanasia takes place when a person says that, well, it just cannot go on any further, the pain is too much, and for example, the painkillers are injected in far excess quantity, which leads to cessation of certain bodily functions. But in this context, passive euthanasia, which is the living will, it has been upheld by the court, where patient beforehand says that there are certain procedures of medicine which should not be, which his body should not go through. And I think that has been upheld by the Supreme Court. We need to go into the detail, and I think Jessica will be able to get us as to whether the court has made a distinction between active euthanasia and passive euthanasia.
Right. Let me now quickly go over to Jessica and get details of, Article 21 of the Constitution, which extensively spoke about this. Jessica, why don't you elaborate for our viewers?
Absolutely, Akansha. Now remember, when this Constitution bench was hearing this matter comprising of Justice A.K. Sikri, M. Khanvinkar, D.Y. Chandrachud and Ashok Bhushan, they had even earlier indicated that during the hearing that they might recognize the execution of living will in cases of passive euthanasia as the right to peacefully die, which is a fundamental right to life under Article 21 of the Constitution, as you also pointed out. Now, Article 21 of the Indian Constitution provides that no person shall be deprived of his or her personal liberty except according to procedure established by law. Now, this is important, and this takes precedence in many decisions that the Supreme Court takes, and it is very, very important to understand how Article 21 is also played out here in context of the Supreme Court verdict.
Right. All right. There is some technical difficulty out there. We will quickly go across to Karthike for now. Karthike, this has also been a major topic of debate, you know. The centre earlier had opposed recognition of living will and said that the consent for removal of artificial support system given by a patient may not be informed one and without being aware of, you know, medical, advancements. The centre was against this. Why don't you elaborate on the debate?
You know, Akansha, the whole, our law is embedded in Victorian morality. The social genesis of our law is in the codes which came into this country when the British trading companies arrived. They got codified after 1857. And then came, the paraphernalia in terms of the Macaulay and the grid which exists today. Most of our laws are 100 years old. Now, in this case, what happened was that suicide was criminalized. Earlier, for example, there have been many, obviously those were patriarchal institutions, but taking one's own life in context of honor or the sense or to preserve the larger well-being of the community was not criminalized. They were patriarchal in nature, but suicide got criminalized. Now, in this context, this assisted, non-assisted, voluntary, involuntary, passive and active euthanasia got morally complicated. Now, the issue arose from the the debate on the morality, which was whether a person has the right to die, whether some other person has the right on other person's life. What should be, is right to life also about right to die with dignity? Is there something called right to die if you have right to life? Now, the court has gone into those grey areas of morality. Court has addressed those areas whereby with gradual success of medicine, Akansha, the life expectancy have gone up and people don't die of at large of snake bites, or they don't die of viral diseases. They die of lifestyle old age diseases. Now that takes a huge toll on your own body, the body of your family, and in this context, the debate took place that what should happen to a person if he feels that he should not be subjected to invasive treatment when he can't take a decision about his own body during the course of treatment. That's where the debate was centered. And in this debate, it's not a simple debate. This debate is about what should doctors do in hospital, what should be the role of the family, where is the right of an individual, what should be the position of state on it, what morality should be enjoyed at that point of time, who has that right at that point of time to take that person off the life support system. That right has now gone to the person himself. If, for example, there are many cases in which consent of the family has to be taken if the person is on life support system. For example, you look at the classic, I'll give you a classic example, the Jayalalitha case. So she was on life support even when the doctors knew that nothing could be done, because it was a question, who will pull that plug off. So these are the issues which have been resolved. But I think this is law is an expression of social morality, Akansha.
Right.
And this new law puts our new social morality in tune with the new laws, in the sense that there is a new India, so there is a new law.
Right. Karthike, we should also go over to Advaita Kala, who's joining us here. She's a social activist. Advaita, the SC has finally recognized living will made by terminally ill patients for passive euthanasia. What is your take on this historic verdict?
Euthanasia is an exceedingly complex moral argument, really, because around the world, not just here, there are many religious questions that arise out of it. There are philosophical concepts surrounding death and life which emerge from it. I think in liberal societies, and we must view ourselves as one, the right to your own body is an inalienable right. And that means when it comes to your body in terms of the female body and pregnancy and childbirth and things like that, and certainly even in more distressing situations like being terminally ill. and looking for a way to end your life with dignity. I think that's something that needs to be upheld as well, as complex as it is. I think if you have the right to life with dignity, then you have the right to death with dignity as well. As long as you are not incapacitated when you make that decision or when you decide that that is what you need, because there is like with every law, there will be a room for it to be manipulated for situations wherein caregivers may not necessarily want to care for someone who's terminally ill. So there is complexity even from the point of view of just the enforcement of this. But on a broad spectrum, if you ask about individual rights, then I think the right to your body is inalienable.
Right, Advaita. Advaita very aptly said that the right to your body is absolutely most imminent. But I would like to ask you, how would you discriminate, this verdict in terms of passive euthanasia versus active euthanasia? How would you look and decode the two?
Well, one has to, I haven't read the verdict as yet. So only when I read it will I be able to, form some sort of assessment on it. And, that it would only be fair to comment on it as well. But I go back to my point about, the person and really, are they incapacitated? Are they, in a position? Because if it's a terminal disease, if it's a degenerative disease, then of course the person gets increasingly incapacitated in terms of making these choices. So I think those factors come into play.
Right, Advaita. Thank you so much for speaking to us here on WION. Kartikeya, we just heard what Advaita had to say, and she said that the right to your body and to die with dignity, it's of utmost importance. Also, let's go back to the Supreme Court verdict. And, the Apex Court has laid down certain guidelines. Why don't you elaborate those guidelines for us?
Okay. Now, what has happened is that there was a 5-judge constitution bench of the Supreme Court. It was headed by Justice Deepak Misra, the CJI. Now, it says in its operative order that human beings have the right to die with dignity, and it recognizes living will made by terminally ill patients for passive euthanasia. The court directives on this will prevail until Centre brings in the legislation. The 5-0 ruling, it was unanimous. 5-0 ruling was given by this constitution bench, and it says that human beings have the right to die with dignity, and bench announced this. Now, this is like upholding their own order, so which means that there will be a legislation to this context, which means that this matter will go to Parliament, Akansha. There have to be lawmaking in both the houses, but this will also open venue for debate, because now it's a court judgment. Only Parliament can, like for example in Shah Bano case, it was a court judgment, but Parliament overruled the Shah Bano verdict. So the Parliament in itself will have the right to review this, because this is not the, now this will have to be debated whether it falls within the...
Kartikeya, I'm sorry to have interjected you there right now. We are also joined in by Anumeha Jha, who is a senior research analyst on from Common Cause. Anumeha, this is indeed a huge victory for Common Cause and for the entire nation. How do you look at this verdict?
This is a huge victory for us, because when the centre had made its guidelines, it had completely omitted living will. It had not even mentioned living will, though our entire petition was based on focus on living will. So the centre had talked of passive euthanasia, but it had not mentioned living will at all. So this is, like, I have not read the verdict, I've just come to know that centre has, the court has ruled in our favor, has given this huge verdict. So it's a huge verdict, and I need to go and just read up on the exact order.
Right. Since you and your NGO Common Cause rallied for the cause of the living will, why don't you elaborate for our viewers about the living will and how important it is to passive euthanasia?
Living will is different from passive euthanasia. In the sense, living will, when I'm completely conscious and when I'm not ill, I make an advance directive, in the sense that if in future, if I happen to be incapacitated in any manner or suffer from some terminal illness, I should not be given any kind of life saving procedure, which So that kind of advanced directive is what living will is all about.
Right, Anumeya, so you just explained it that it's an advanced directive when the person is alive and can issue a living will to actually direct the future course of treatment or opt for euthanasia, right? So it's very important, let me get you clear out here, that it's very important to have that directive when the person is actually living and not passive.
It should not be invasive, yes, yes.
Right.
It should be left to die with dignity. So this is all about what living will is about. And passive euthanasia is destroying the life of the
Also, Anumeha, why don't you elaborate for our viewers, the difference between passive euthanasia and active euthanasia? All right, I think we've just lost Anumeha Jha. That was Anumeha, Senior Research Analyst from Common Cause, the NGO which rallied for passive euthanasia, and she just shared her views with us. So there you go, the passive euthanasia has been legalized and the verdict is finally out by the Supreme Court. The NGO named Common Cause had petitioned the Indian Supreme Court to recognize living will of a person. And now we are also joined in by Anand Yagnik, a human rights lawyer, who will just share his perspective on this news story. Anand Yagnik, how would you look at this verdict by the Supreme Court?
This is one of the most landmark judgments I've ever come across in independent India. Euthanasia means right to die in a compelling medical circumstances. For the first time, Supreme Court has accepted right of a person to die in a compelling circumstances. This means that right to life is expanded as enshrined in Article 21 of the Constitution of India as right to die as well, subject to availability of certain medical conditions. Whether it is active or a passive euthanasia, the question is, under Indian law, no one has a right to die. But if there are medical circumstances which are so compelling, then the Supreme Court, by the verdict in question, has permitted a medically ill person to express his willingness not to continue his life and die. In simple terms, right to life now includes right to die in a compelling medical circumstances. That's all.
Right. Mr. Yagnik, also, for our viewers, decode the difference between passive euthanasia and active euthanasia.
Well, it would be difficult for me because I'm in Ahmedabad and I haven't read the judgment. Judgment has just been announced, and therefore, before reading the judgment, it would be very difficult to philosophize what is the distinction between active and passive euthanasia.
Right.
The question is that for the first time, Supreme Court in India has accepted right to die in a compelling medical circumstance.
Also, it has acknowledged the importance of living will to passive euthanasia. Why don't you elaborate the importance of living will to passive euthanasia?
Well, nobody is in a condition to contemplate what will happen to him or her in future. But if at all a person suffers from disease which doesn't have a kind of solution to it, and a person cannot live in a meaningful manner, because right to life includes right to live in a meaningful manner. But if medical compulsion creates a situation for a person where he lives a vegetative life, where he lives but he does not live meaningfully, then he can express his inclination to die, and that inclination is now acceptable, and that's what passive euthanasia is about, and a willingness to die, an acceptance of that will from a medically ill person who cannot be cured to die.
Right. Right, Mr. Yagnik, thank you so much for joining us here on WION and sharing your views. And now let me quickly go across to yet another senior lawyer joining us on WION. Geeta Luthra. Ms. Luthra, what are your views on this historic judgment?
So I think it's a brilliant judgment. It's something which we were waiting and which the courts have been looking at with interest for many years. The only issue was misuse, and the other issue was this concept of human life being sacred, and that we don't have a right to take away our life if we don't have a right to give a life. But still, despite that, the pragmatic view has always been in favor of euthanasia, except the fear of abuse at the instance of those who may be family members, who may be inimical, those who are in a position to inherit properties. So keeping all those parameters into view, if one is careful about the circumstances in which passive euthanasia is practiced, I think we were waiting for such a judgment for a long, long time. And I'm really happy at the verdict, and we look forward to it being put in place with all the protection and all the various parameters the court would have laid down to ensure its prevention of its misuse.
Right. Ms. Luthra's right, the right to die peacefully is part of a fundamental right to life under Article 21 of the Constitution. Would you please elaborate for our viewers on this?
So the right to life is a fundamental right enshrined in Part 3 of our Constitution. That right to life includes various aspects of living, and with all the various parameters thrown in. Now, one of the concomitants of a right to life is a right to die. Now, if you have a right to die, the question is, how do you assure that a person has a dignified death? Now, there are various countries where euthanasia is permitted. Some of the countries in the Schengen countries, Switzerland, all of them have passive euthanasia as a right. And therefore, there are many people from all over Europe, all over the world, that go there to either Norway or to Switzerland, and therefore there practice euthanasia. Say they have terminal cancer of a kind which is extremely painful, extremely non-livable. There is a person in a vegetative state, families which have a child in a vegetative state with a problem which is congenital of a nature that such a child would be vegetative. Now, it is in a vegetative state that passive euthanasia is being permitted by the courts. And I think they would have hedged in with medical certificates of doctors, either of government or other hospitals, with a reputation such that there cannot be a misuse of the provision. The fear in such a provision, because otherwise it's all good, is the fear of misuse. And if that is hedged in, all that one can say is it's extremely welcome. It's part and parcel of the right to life. Right to life is one of the fundamental rights. And therefore, it's something which is completely welcome, and the courts have been looking at this issue from long.
Right. Thank you, Ms. Luthra, for joining in and bringing in your perspective. And that was a very, very valid point that you made, that the fear of misuse is also something that the courts have been working upon, have been trying to address. Let me quickly go across to our correspondent, Jessica Taneja, who's also joining us live. Jessica, Ms. Luthra, who's also a senior lawyer, she just pointed out that, the fear of misuse is another important aspect which was being worked on and being addressed. What's your take on the fear of misuse?
Well, absolutely, Akansha. It's an important point to make, because when the NGO had filed this case, Common Cause, on behalf of Prashant Bhushan, he had also made the same thing. He had said there has to be a robust system of certification for passive euthanasia and legal recognition of living will in India. That is important, but we need to give safeguards to ensure that this particular order or this particular judgment is implemented in its full form. And putting safeguards and measures is important when we talk about passive euthanasia in particular as well.
Right, Jessica. Thank you so much for bringing in that perspective here on WION. And with that, certainly a very landmark verdict coming in out there on passive euthanasia. The Supreme Court has finally upheld the verdict, the right to die with dignity, the right over your body. That is what the Supreme Court has finally upheld.